Expose evil here. Like, share, subscribe. Now here's something else I would file. It's affidavit of fact, notice to dismiss, no case or controversy. And take note that we're not filing motions. A man doesn't file motions. File notices and demands. When you demand something, don't think it's like being rude or you're out of pocket or you're not supposed to do it. Demand means by right. So you're doing it by right. When you say demand, you're saying you're doing it by right. So you would demand a discovery and inspection of evidence. I have to find one of those too. I'll do a video on that also. But you see here, it's again challenging jurisdiction. Notice to dismiss, no case of controversy, be it known the aggrieved party, a common man respectfully moves the honorable court and or judge to take judicial notice and notice to dismiss in its entirety. Therefore, let the alleged moving party, the state attorney prosecutor, produce the verified document proof of jurisdiction and venue as required by law and certified on the official court record. Court must prove on the record all jurisdictional facts related to the jurisdiction asserted. Latina versus Hopper. And then Chicago versus New York. The law requires proof of jurisdiction to appear on the record of the administrative agency for all administrative procedures. Right? And if they want to claim it's criminal, we need a victim. I'll show you on the next page. Real quick, try to explain a little bit about special appearance or special visitation. Special appearance is a tool defendants can use to challenge a court's jurisdiction over them. If a court does not have personal jurisdiction, or there are other errors like the service of process, many states allow defendants to challenge the lawsuit without submitting to the court's jurisdiction. Normally, if a citizen were to make a general appearance, the jurisdiction issue would be waived. For federal courts in some states, a defendant does not have to make a special appearance, but they are required to challenge the given error before addressing the actual claim itself, as one would in a general appearance. What is in propria persona? When someone is challenging the personal jurisdiction of the courts, he's appearing in his own person or in propria persona. A person must be careful not to either commit an act or admit to act in a way that would give the courts personal jurisdiction. Once he does not do either of these, he gives the court permission to proceed at the court's own discretion. Any arguments against the court's jurisdiction would therefore be deemed frivolous, and the court would continue to proceed full steam ahead with its course of action. Now comes so-and-so of the family of so-and-so, hereinafter so-and-so, I, a common man, in my proper person, proceeding sur juris, my visitation appearance is special only and not general or voluntary in nature, therefore with explicit reservation of all my natural and inalienable rights, without prejudice, while retaining all my secured liberties at all times, and not waiving my fundamental rights and remedies at common law and equity in all civil or criminal actions, or my rights to substantive and full procedural due process of law as of my inherent rights. I explicitly demand my right to trial by jury of my peers in a court of common law. In the above styled case and numbered cause, therefore I respectfully move the honorable court in the interest of justice to immediately strike dismiss with prejudice the following matter of cause. You'll put your case number. Failure to state a claim upon which relief can be granted. In fact, no justiciable case or controversy is presented according to the organic law of the state. The accused, a common man of inherent jurisdiction, as of my intrinsic birthright, herewith challenges an alleged arbitrary presumption of jurisdiction and venue of the court on and for the official public record. Where a defendant of the court challenges jurisdiction, the plaintiff cannot rely merely on allegations on the complaint, but must instead bring forth relevant, competent proof to establish jurisdiction. Murphy versus United States. The burden shifts to the court to prove jurisdiction. Roseman versus Lambert. A plaintiff bears the burden of establishing jurisdiction by a preponderance of the evidence. Reynolds. 846 F2D at 748. Accordingly, the accuser, plaintiff, bears the burden of proof to provide empirical evidence that the accused, a common man, is subject to the plaintiff's employers, a private corporate administrative agency's legislative equity jurisdiction in which this court intends to sit to hear and determine only the facts of this matter, and not the law arising from the unlawful and unconstitutional legislative bill of attainder in the form of a bill of pains and penalties, which is repugnant to the letter and the spirit of both the federal and state constitutions, also being outlawed and prohibited by both. See the Constitution of the United States, Article 1, Section 9.3, Article 1, Section 10.1, and the New Jersey State Constitution, Article 4, Section 7.3. All legal definitions quoted from Black's Law Dictionary, 6th edition, 1990. Bill of Attainder. A legislative act, no matter what form that applies either to named individuals or to easily ascertainable members of a group in such a way as to inflict punishment on them without a judicial trial. United States versus Brown. That's 381 U.S. 437. At 448 and 449. An act is a bill of attainder when the punishment is death, and a bill of pains and penalties when the punishment is less severe. Both kinds of punishment fall within the scope of constitutional prohibition. U.S. Constitution, Article 1, Section 9, Clause 3, as to Congress, Article 1, Section 10, as to state legislators. Black's Law Dictionary, 6th edition, page 165. Bill of Pains and Penalties, statutory provisions for punishment without judicial determination of guilt, similar to the Bill of Attainder, except that the punishment is less severe. Prohibited by the United States Constitution, Article 1 and 9, Clause 3, Congress, Section 10, states. Last Law 6th edition, page 168. The argument which follows sets forth the nature of controversy at law. The Honorable Court and Judge is bound by its sworn oath of office to sit on the law side of its jurisdiction, to hear an alleged controversy in a neutral capacity, and to make a fair and impartial determination. This document and the argument contained herein is intended to be the basis and foundation for further action in interlocutory appeal, should the state attorney prosecutor fail to meet their burden of proof and produce verified documentary evidence of jurisdiction and venue, certified and recorded on the official record of the court, and bring forth relevant, competent, tangible proof of living, breathing, natural physical flesh and blood, carbon-based, self-aware, sentient being, a common man, woman, the victim of a crime, the real party in interest who initiated this claim, also produced the actual verified documentation that the accused, a common man, has caused harm or injury or damage to anyone and has lost his inherent birthright and status as a fully constitutionally empowered, free-born, sovereign American state national. If the prosecution cannot produce the verified legal documentary evidence, he or she are possibly perpetrating fraud upon the court.